Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in this video, let us learn about the construction of a penal statute. So, while construction of a beneficial statute, it is necessary that the courts should follow a liberal approach. While construction and interpretation of a penal statute is concerned, the approach of the court cannot be liberal and therefore such statutes must be scrutinized more in detail. Like in other statutes, we can't straight away just read the definition or read the what is written in the statute by the grammatical or literal meaning. But we need to get into more detail what the penal statute says, and we have to follow other rules also. So, the rules to be followed while interpreting and constructing a penal statute should be twofold. Like, firstly, the statute should not be constructed liberally as far as possible. The intention of the legislature should be followed. And secondly, when there is ambiguity in the statute, and if one meaning would release the accused and another meaning would convict the accused, then the court of law must favor the first option and see that the person is not punished. So, however, we hear in the movies that to be strange, but the true intention of the law is that even if the 10 guilty persons escape the law, one innocent person should not be punished for the offense he has not committed. Thus, the benefit of doubt, so as to say, it is always given to the accused and not to the prosecution. So, this might be a filmy dialogue, but this is true. The true intention of the legislature should be followed while interpreting the statutes. Coming to the judicial approach, in the case of W.H. King versus Republic of India, here what happened is the accused was charged for the offense of transferring the government leased property to another person because this accused person has taken some amount illegally. So what he has in his hands is only the government leased property. So what he did, he transferred the property to another person, and so after the charging of the offense, what he said is, he argued with that I didn't broke any statute, I didn't mean of transferring the leased property, but I only assigned the property so as to make you pay the lease amount on time. I didn't relinquish the property, but I only assigned the property, and no other statutes is broken. So what happened is the court of law accepted his argument and he was found not guilty. In another case of Kedarnath versus state of West Bengal, generally all the rules followed by the statute, they should follow the prospective legislation and not retrospective legislation. And if the penal law lays down one punishment at the time of committing the offense and the said law is modified and the punishment is enhanced by the subsequent amendment, the accused person is, if found guilty, will be given the punishment as it existed at the time of commission of the offense and not at the time of delivering the judgment. So, what in the past he has, for example, if the accused has accused is found guilty and what punishment is given in the past is of less severe, and what punishment is given today after the modification, then the punishment which is the punishment to be given is the time at the time of committing the offense, what kind of punishment was there, that will be given and not at the time of delivering the judgment. So in this way, the court follows the rules of prospective legislation and not retrospective legislation. Here we can easily say that the construction of a penal statute is for the beneficiary of the people who are seeking for the justice. In another case, Chunnibai versus state of Bombay, here some of the workers in a factory died due to inhaling of poisonous fumes when they entered into a closed and confined space. Here the question arose whether the owner deliberately sent them to the closed and confined space. Was there any force by the owner? So here what happened is the prosecution failed to prove that there was a force or enticement by the owner on the workers to enter into that closed or confined space, because there was no proof and no evidence to prove, and there was a failure of prosecution in proving that. So the accused was released and he was not found guilty. In another case of Sarju Prasad versus State of Uttar Pradesh, here what happened? A person was selling adulterated food materials. So, as per the section 16 and section 19 of the Adulteration Act 1954, even if the person knows or without a prior knowledge or with the absence of knowledge also, if he sells the adulterated products, he will be penalized. Even if the person doesn't know about the adulterated food materials, selling of the adulterated food materials itself is clearly given in the act that selling is a offense, even the person knows or doesn't know that the food is got adulterated. Coming to another case law in Ranjit Uddeshi versus State of Maharashtra. Here, the Ranjit Uddeshi, he was a bookstall owner in Mumbai and he was selling one of the book which is having obscene content, and to that too for the people who are under the age of 20 years. Actually, this book is prohibited in many other countries including India. So this person, the Ranjit Uddeshi, he was found as an accused person. He should be penalized because he should have a minimum knowledge of what book is prohibited in for sale in India and what book is allowed for sale. So he lost a little logic of what is enough for him to know that the book was prohibited for sale in India. So he was found guilty and he was penalized under the section 292 of IPC. So even with the knowledge or without the knowledge of the obscene content of the book, but he should have a minimum knowledge of what books are prohibited for sale in India. So in this case he was penalized. In another case of state of Punjab versus Gurmeet Singh, here Gurmeet Singh was found as one of the accused person for the offence of dowry death under the section 304B of IPC. Here, but Gurmeet Singh is not the direct relative of the person who was caused dowry death. Here in this dowry death under section 304B of IPC, they said that any other relative of the husband. So here any other relative of the husband means the who is related by blood or adoption or by marriage, but he is not completely directly related to that any other relative of husband, because here the accused is the brother of the husband of the maternal aunt of the deceased husband. So he is having a long tailed relationship. He can be an accomplice in this case, but he cannot be penalized under the section 304B of IPC, which is an offense for dowry death for the woman. So what section is to be penalized for a person is clearly taken into consideration. In the case of Dashtadrup Singh Rathod versus State of Maharashtra and another, here the complainant is complaining about the dishonor of the checks for the insufficiency of the funds received from the respondents. So he gave a notice according to sections 138 of the Negotiable Instruments Act 1881 to the respondents. So he gave notice that within 15 days of time I want my money back. But here the respondents, only 3 of the respondents received the notice, and the other person, he did not receive any notice. So the court gave a clear distinction after filing this case. The court gave a clear distinctive provision that according to Negotiable Instrument Act 1881 of section 138, you should, how many people you are against them, you have to give notice to each and every individual according to section 138. Otherwise, the person who didn't receive the notice will be out of the section 138 of the Negotiable Instruments Act. This was a clear provision that Supreme Court decided that no further interpretation was necessary, and other references to the Criminal Procedure Code were unwarranted. As such, we have come to the end of the video. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe my channel for many more interesting topics. Thank you.